Welcome to the latest episode of Risk Settlements Podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar on the latest trends and developments in the world of class action and commercial litigation. I'm your host, Kevin Skrzowski, with the litigation consulting firm Risk Settlements, and today we will be discussing the impact that last year's Facebook decision had on the landscape of TCPA litigation over the past almost 12 months now. I'm pleased to be joined by Terry Gonsalves, a partner and trial lawyer with the law firm Alston & Bird. Good morning, Terry. How are you today?
Good morning, Kevin. Thank you for inviting me to participate in your podcast.
Absolutely. Terry, perhaps it would be best just to start, you could tell the audience a little bit about your career, your practice, and some of your primary areas of focus right now.
Sure, I'd be happy to. I'm a partner in the litigation and trial practice group at Alston & Bird. My practice encompasses three main areas. As you mentioned, I'm a commercial litigator. I'm a trial attorney who's tried more than 25 cases to verdict and appear in federal and state courts across the country regularly. I also handle government investigations, regulatory inquiries from federal and state regulators, and I conduct internal investigations on behalf of my clients. Those investigations are for companies and they're related to compliance with their internal policies and procedures, as well as compliance with federal, state, and local laws. I am the chair of Alston & Bird's education practice and regularly represent colleges and universities in a variety of matters. And I have a consumer protection practice where I represent clients in numerous industries. And within that consumer protection practice is my defense of TCPA cases, both individual cases and class actions. I've probably defended close to 100 TCPA cases in my career, and I look forward to our discussion about the TCPA today.
That's great. That sounds like a very interesting and exciting and diverse litigation practice that you have, and it sounds like you're a very busy attorney. And I thank you for taking some time to join me today. So it sounds like definitely a significant portion of your practice is the defense of businesses who are accused of alleged TCPA violations. And as most of TCPA world knows, we're coming up on the 1-year anniversary of that landmark Supreme Court decision in Facebook regarding the TCPA. Can we start by having you provide a quick review of the key holding or the key holdings of that decision?
Absolutely. And you're dead on. Facebook versus Duguid was decided on April 1, 2021. It was a unanimous decision from the United States Supreme Court addressing the definition of an automatic telephone dialing system under the TCPA. The TCPA defines the ATDS as an equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. Some courts across the country had ruled that an ATDS need only store or produce telephone numbers and did not need to use a random or sequential number generator. The Supreme Court disagreed and held that the definition of an auto dialer requires that in all cases, whether the equipment stores or produces numbers to be called, the equipment must use a random or sequential number generator. That is very significant because most of the modern day dialing systems used by companies do not have the ability to dial using random or sequential number generators. So a very significant holding, Kevin.
That's very interesting and agree, very significant, especially in terms of the technology that is really at the focus of the holding of that decision. But now many thought that the Facebook decision was going to curtail TCPA litigation, but in fact, it did not. And one area where we've seen the TCPA plaintiffs bar focus much of its attention over the past year is around do not call lists. So what are the potential pitfalls that still exist with regards to calling numbers on the DNC list?
Yeah, the decision was a landmark decision, and it did have an impact on the TCPA landscape without question. I did see some stats that there was a reduction of TCPA cases filed after the Facebook decision, but you're absolutely right. It did not eliminate the TCPA at all. The other areas that are within the TCPA that remain very active are claims related to pre-recorded messages or artificial voices, and alleged violations of the do not call registry. We've also seen lawyers shifting their claims to state telemarketing laws, such as those in Florida.
So it sounds like when it comes to pre-recorded calls or the DNC list, they're still operating by a completely separate set of rules, and any numbers that were going to be on the DNC list would need to be scrubbed, even if you're not using an automated telephone dialing system.
And that's a very important distinction, and exactly right, which is those other two provisions do not require the equipment used to be an ATDS.
Right. Still significant liability there. Now, I had reached out to you a couple of weeks ago because I had saw that you had recently won a motion for summary judgment in the putative TCPA matter, Johansson versus E-Financial in the Western District of Washington. Now, in that case, it looks like the plaintiff alleged two things: that he was called without his express written consent and at a number that was on the DNC list. Can you discuss the defenses to an alleged DNC violation and which ones that you successfully raised to win summary judgment in Johansson?
Sure. In that case, well, the two primary defenses that we leveraged in the Johansson matter was that he did, in fact, provide prior express invitation or permission, which is also known as prior express consent. And we also leveraged a little used affirmative defense within the TCPA known as a safe harbor, which states that a company will not be liable for certain calls if it had in place certain standards. And the court in that case found that Johansson had provided express invitation or permission, and that E-Financial was able to utilize the safe harbor defense in that case.
And it's very interesting because you said it's little used, but I know that much has been written on the market since your victory in this case around advising defense counsel not to forget to raise the affirmative defense on the safe harbor. I think it's an incredibly effective defense to calling or allegedly calling someone who is actually on the DNC list. But in terms of the safe harbor, there are certain elements to it. Can you take us through what you need to prove to show that you're in compliance with the TCPA safe harbor?
Sure. To leverage the safe harbor, you must show 5 specific things. First, you must show that the call that is at issue was placed in error. And what that means is that the company had a reasonable belief that the call it made was trying to reach one of its customers who had consented to be called. If the call was made in error, the company need also establish that it has written procedures to comply with the national do not call rules within the TCPA. It must have established training programs for its personnel, demonstrating that it's trained its personnel on the procedures to establish compliance with the national do not call rules. It must maintain an internal DNC list and have the list of individuals who requested not to be contacted recorded within its business records. And the last thing it must show that it accesses the national do not call database to determine whether or not the individual who was being called was on that DNC list or not. So it's error, written procedures, training, recording of a DNC list, and access to the national DNC database.
So now satisfying all of those elements could perhaps be a pretty high standard. There are a lot of requirements in order to successfully raise that defense. Now, the judge in Johansson did provide some commentary in the opinion about strict compliance versus substantial compliance in terms of fulfilling every single one of the elements of that defense. Do you have any advice you would give the audience when it comes to adhering strictly versus a substantial compliance with the TCPA safe harbor provision?
I do. In the Johansson case, E-Financial had satisfied all of the elements of the safe harbor except the last one, which is access to the National Do Not Call database. Even though it had not purchased access to the National DNC, the court in Johansson found that eFinancial was entitled to the safe harbor because it had substantially complied with the provisions. So what is substantial compliance? Substantial compliance is when the regulatory requirements or the essential statutory purposes have been fulfilled. It's an equitable doctrine designed to avoid hardship in cases where a company has done all that it is reasonably been expected to be done. It had been adopted in the Ninth Circuit in other regulatory contexts, just not in the context of the TCPA. In fact, I'm not aware that substantial compliance had been applied to the safe harbor provision of the TCPA in any case as clearly as it was in the Johansson case. And so the key to substantial compliance in the context of the TCPA is that you must fulfill the purpose of the TCPA, and that is to protect consumers from the unwanted intrusion and nuisance of unsolicited telephone calls or text messages or fax advertisements. The court in Johansson found that eFinancial had substantially complied with the safe harbor provision of the TCPA because its policies and procedures satisfied the TCPA's purpose because, among other reasons, it only placed calls to consumers who consented to be called. Mm-hmm. Thus, even though eFinancial did not subscribe to the National DNC registry, the court found it still entitled to the benefits of the safe harbor provision. Now, you asked, what is my recommendation for strict compliance or substantial compliance within the safe harbor provision? My advice is that the company should do its best to adhere to strict compliance and meet every one of the elements set forth in the TCPA for the safe harbor. And the reason I make that recommendation, one, it is the most conservative one, but two, it is because the law on substantial compliance in the safe harbor context of the TCPA is not settled across the country, and other courts may not adhere to the Johansson opinion and adopt substantial compliance for the safe harbor.
And of course, I think that's great. And I think that's the correct guidance and advice to give. But I really do like the conclusion that the judge reached in Johansson, tying substantial compliance to truly the legislative intent of the statute and providing a very clear and rational decision in that case. I definitely think that was a win for the good guys. But now you had mentioned there was other defenses that you had raised, and there were really some other storylines impacted by this decision, which are quite interesting. That of TCPA disclosures, and then one of serial plaintiffs as well. So we had previously seen the court in the Mantha case rule that a caller cannot reply on a TCPA consent disclosure on a website unless the consumer separately entered into some type of e-sign agreement to do business with the caller electronically. But that's not how the court ruled here. What were some of the actions that Johansson took in eFinancial that led the court to rule differently than in the Mantha case?
Yeah, Joseph Mantha versus Quote Wizard is a very different case than the Johansson versus eFinancial case. For one, the magistrate judge issued his report and recommendation in the eFinancial case on June 11, 2021. Mantha was decided by the chief magistrate judge on December 13th. The district court in Johansson adopted the report and recommendation on January 18th, so about 1 month after Mantha was decided. But the Mantha decision wasn't brought to the district court's attention in Johansson, and it's not referenced in its opinion. It's also important to note that Johansson did not allege that consent obtained via a website, absent a prior agreement to do business electronically, was not valid. That wasn't his claim. But the magistrate judge and the district court judge in the Johansson case did find that submission of consent on a website is valid consent. Both of them cited a 2012 report and order from the FCC that said the FCC has determined that a signed written agreement requirement may be fulfilled by submission of a website form. That authority was cited both by the district court judge and the magistrate judge in Johansson. It's interesting to note also that when the district court judge in Mantha adopted the magistrate's recommendations, which was on February 3rd, 2022, the district court did not address the e-sign act that the magistrate judge. In fact, the district court judge held that it was going to assume, without citing, that Mantha did not consent to contact for three reasons. And one of those reasons was that the defendant did not seek judgment on the ground that it had obtained consent from the plaintiff. The defendant in Mantha was actually arguing that it could reasonably rely on the consent that it received, not that it necessarily came from the plaintiff. And this reasonable reliance defense was an assertion that the TCPA is not a strict liability statute, but most courts hold that it is. And one last point is Mantha was decided in the District Court of Massachusetts. Johansson was decided in the Western District of Washington. So the Mantha opinion was not binding on the court in Johansson.
Certainly. And that's all understood. But in terms of providing consent, though, wasn't part of the analysis of the ruling tied to the fact that, Johansson had provide his number to a website. He'd filled out a form expressing some type of interest in products or services. But he had also done this many times in the past, in many other cases, submitting website forms and ultimately really feigning interest in products or services to try to establish TCPA liability.
That's exactly right. And in the Johansson case, Mr. Johansson claimed that he did not provide consent for eFinancial to call him. And he complained that he did not submit the web lead that eFinancial had received. But the court didn't agree with that and ruled, in fact, that he had provided.
Mm-hmm. And again, I think great victories for you and your client in raising the defenses for both the express written consent rule and raising the TCPA safe harbor as an affirmative defense as well. As we mentioned in the beginning, though, if you're using a pre-recorded voice or you're using an automated telephone dialing system, it's a whole different ballgame. And a lot of the DNC calls and the pre-recorded calls claims have really picked up over the last year. That seems to be the bread and butter of TCPA filings right now. Do you anticipate that DNC claims and pre-recorded call claims are going to continue to dominate TCPA litigation? Or do you think that the plaintiff's bar will creatively come up with some other areas over the next year to allege TCPA violations?
I'm of the view that the plaintiff's bar is going to continue to focus on pre-recorded calls and the DNC provisions.
Okay.
Because the current definition of an ATDS requires the company's equipment to use a random or sequential number generator, and most modern day dialing systems do not use those, that's just not a viable path for the plaintiffs in most cases. So the DNC and pre-recorded message claims are the more viable path, at least so long as the definition of an ATDS is not changed by legislation.
Of course, that certainly makes sense. Now, the big question is, so what advice do you give clients today to help them ensure TCPA compliance? I know one of the methods that I'm very familiar with is the use of text messages as perhaps being the safest method of outbound marketing. And as defense counsel, perhaps the best thing would be to counsel your clients away from pre-recorded calls and towards the text channel. What advice are you giving your clients today to help them ensure with TCPA compliance?
So my strongest advice to my clients, or maybe my first piece of advice, whether they're defending ATDS, pre-recorded DNC, is get express written consent to make the telephone call, to send the text messages, and make sure that that consent includes the company's name in the consent form. And of course, keep accurate, verifiable records of that consent. Strategies such as the one you're suggesting is using text messaging or not using pre-recorded calls and not using automated dialing systems all further enhance the ability to defend a claim should one come in. And I think those are all reasonable strategies to remain in compliance with the TCPA and to defend a lawsuit if you do get one.
And I think that is all terrific guidance and advice. Now, Terry, those were the main questions that I had for you today. And I really think that's about all the time that we have for today. Before we leave, I want to thank you. It was a real pleasure speaking with you, having you as my guest today. And I want to thank you for all of your time and the valuable insights that you've shared with me and our audience today.
Very much appreciate being invited to participate, Kevin. Look forward to speaking with you again soon.
Great. Thank you. And before we go, do you have any upcoming programming that you would like to discuss, whether it's TCPA related or related to any of the aforementioned practice areas that you're working on?
I do. As I mentioned, I am chair of Alston and Bird's education practice. And at the end of April, on April 26th, we are hosting at the firm in Atlanta, half-day conference addressing higher education. We are going to have a panel on the regulators and what the regulators are thinking about, M&A in higher ed, and corporate governance. And we are looking forward to an in-person conference in our offices, and we're excited to see our clients and guests.
Sounds like a great conference, and it will be nice to go back to having some face-to-face interaction. Now, if anybody would like to contact you and have a deeper discussion on any of the TCPA-related topics that we covered here today, what would be the best way to reach you?
Sure. They can either call me or email me. My office line is 404-881-7983. And my email address is terrence.gonzalez@alston.com, TERANCE.GONSALVES@ALSTON.com.
Terrific. Thank you again, Terry. And of course, I would also like to thank our audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere where you listen to your favorite podcasts. If you would like to listen to a recording of today's program or would like to learn more about our litigation and settlement risk transfer solutions that are available for TCPA litigation, including things such as class action settlement insurance, please visit the Risk Settlements website at www.risksettlements.com. And of course, you can always reach me directly at kevins@risksettlements.com. Until next time, thank you for listening.